Can the clerk please? The Honorable Supreme Court of the State of New Mexico.
Good afternoon. You may be seated. Thank you. We are on record S-1-SC-41094, matter of Gallagher. Petitioner, you have 10 minutes opening. Enter your appearance and you may begin.
Thank you, Your Honor. Joseph Gonzalez on behalf of the Office of Disciplinary Counsel. May it please the court. This case is about integrity, our profession, and the administration of justice. This court has held in the matter of Cox, which citation 117 New Mexico 575, that the purpose of attorney discipline is not solely to protect clients from being harmed by their attorneys, but also to protect the profession and the administration of justice. In March of this year, the disciplinary board accepted a consent agreement signed by Ms. Gallagher, where she didn't contest that she violated Rule 16803D by failing to give full cooperation and assistance to the disciplinary board and disciplinary counsel. The board recommended that she receive a formal reprimand, which would be deferred for 1 year. And during that time, she would be on probation. As conditions of her probation, she had to pay costs within a certain time, take a CLE in office management and client communication, and in addition to provide monthly reports regarding her supervision by a supervising attorney. As indicated in our motion for order to show cause, Ms. Gallagher continued to fail to cooperate with the disciplinary process. She did not respond to 4 different complaints which were referenced in the motion for order to show cause, despite multiple attempts by our office to get her response. She did not pay her costs within a timely manner, and she had not been providing monthly reports. In her response to the motion to order show cause, Ms. Gallagher stated that she would begin providing monthly reports directly to our office. Since the filing of that response, she has not provided any supervision reports.
Have she responded to the 4 complaints?
She has responded to.
When did that happen?
It happened shortly around the time that she filed her response to the motion for order to show cause.
Thank you.
However, since the filing of the motion for order to show cause, our office has received 7 additional complaints of a similar nature, which he also has not responded to despite multiple attempts. It is my understanding that Ms. Gallagher did respond to some of those 7 complaints over the weekend, but I have not had the opportunity to review those as of yet.
So the ones that you received over the weekend, are they late?
They're very late. They would be at the same position as the 4 referenced in the motion for order to show cause. Our office had already sent multiple correspondence to her directly.
So there's a total of 11?
So she did respond to those 4 in the motion in order to show cause. So as of right now, 7 are pending.
Okay, but there's a total of 11 complaints?
Yes.
Okay, thank
And
you.
this is all since just June of this year.
Thank you.
While we are appreciative of Ms. Gallagher's personal problems, and while I personally have empathy for her as a fellow human, our office does have concerns about her current fitness to practice. All the complaints we received, the 4 referenced in the motion for order to show cause, and the 7 subsequent complaints, all allege the same thing: failure to communicate, failure to keep the client informed, a lack of competence, a lack of diligence. Many of the clients complaining are incarcerated and therefore vulnerable. As indicative of Ms. Gallagher's lack of diligence, she received notice of today's argument on November 7th. She waited until 2 full business days before today's hearing to seek a continuance, alleging that she had conflicts for today's date in 4 cases that are set for jury selection today. A review of the docket of those 4 cases show that notices were sent in those cases in September and October of this year, well before the November 7th notice for today's oral argument. She waited until the week before the hearing to seek a continuance. Again, as this court has held, the purpose of attorney discipline is not solely to protect clients from being harmed, but also to protect the profession and the administration of justice. Ms. Gallagher has demonstrated a pattern of misconduct, and I don't believe revocation of her probation and the issuance of a formal reprimand will be enough to satisfy this matter. Our office believes that Ms. Gallagher should be indefinitely suspended for a period of no less than 1 year and take the opportunity to attend to her personal issues and to get her law office management under control before being reinstated.
Counsel,
Sorry, go ahead, Justice Vargas.
let me ask you a question. You're asking us to indefinitely suspend her, which is the, usually the punishment after an entire disciplinary proceeding, correct?
Yes.
Has she had any of that process yet?
Not on the new complaints. It's just that this is the same behavior. The reason why she was on probation in the first place was failing to cooperate with our office.
So if we were to agree to indefinitely suspend her, would that be subject to completing these processes, or would the process be done?
I believe the process would be done.
What was the probation, though? It was for a formal reprimand, right? That was held in abeyance?
It was held, the formal reprimand was held in abeyance, and if she completed the probation within the year's time with no new allegations or no new violations of the rules of professional conduct, then she would receive an informal and not a formal.
Okay, so the best you can come out of here is revoke probation and she gets a formal reprimand.
Yeah, yes, based off of the terms of the consent agreement.
Okay, so to Justice Vargas's point, we don't have an adjudication of these other complaints, understanding there are a number of them, but it would be a summary, seems to me a little bit of a summary adjudication of those complaints if we were to indefinitely suspend. Or are you suggesting that as a ends to the order to show cause?
As an end to the order to show cause.
Anything else?
Nothing further.
Thank you. Okay, we'll hear from the respondent, 20 minutes. Understand, counsel, your client would like to address the court, is that correct?
That is correct.
So we'll go ahead and allow that. It'll be on your 20 minutes, you understand that?
Fully
And I will have to swear your client under oath.
understood.
Thank you. You may proceed.
Ty C. Harmon on behalf of the respondent, Sandra Gallagher, who is seated at council table here in the courtroom. Justice, or Chief Justice, you've already covered my initial statements, but first of all, I want to thank the court for allowing my late request, but allowing the opportunity for Ms. Gallagher to be heard. She's had a lot go on in her life. I think more important than hearing from me, I think it's important for the court to hear from you, or from her. Ms. Gallagher has been licensed to practice since 1988, almost 38 years in the state of Texas and New Mexico, as well as the federal courts of New Mexico. Up until the last 10 months to a year, Ms. Gallagher has had no discipline issues. I'm not going to get into the specifics. You've read the response. I fully expect that. Since April of 2024, Ms. Gallagher has gone through some horrific situations over this time period, this 18, 19 months.
So I understand that, and I don't think anybody here doesn't have some empathy towards that. But everything that is laid out in your client's response predates the initial punishment here. It's not, I agreed to this current process, and then other things started to happen. So we've already heard the kind of the challenges of 2024. The idea behind discipline, especially with a deferred sentence, is okay, we get that. We've heard you, and that's why we're agreeing to this deferred sentence. And now Ms. Gallagher still relies on the same exact conduct. Something is amiss here. Either your client doesn't understand where she stands today, because she's relying on things that we've already not excused, but taken into consideration. There's nothing new to excuse the current conduct. So either she doesn't understand it, and that's a significant issue, or she doesn't care. And that is also a significant issue. But something's going on here that suggests to me that your client shouldn't be practicing law right now. And I assume that if we were to proceed forward here, your argument would be it's just a formal reprimand now, because that's what was deferred. That doesn't protect the public.
I understand.
And so what do I do with that? I mean, I have this abiding feeling that your client should not be practicing law. And my job is to protect the public and the profession, but I'm mostly, in this instance, worried about the public.
I understand, and I 100% understand that is your job, and I believe it's all of our job as a part of the state bar. And the best I can answer the question is mental health issues. They don't just, I'm going to take an agreement and they stop.
And that's what I think we all understand that, but a formal reprimand's not going to fix what's going on here. That's the disconnect for me. Is formal reprimand might be embarrassing, but it doesn't actually fix or cure anything, especially if we're focused on mental health. So then what do I do with that?
I understand that, and if I may briefly try to answer the question. I've personally known Sandy for 20 years, maybe a little bit longer actually. I've watched her practice. Sandy can and does practice law well. She does protect her clients. I understand that they may not get communicated with as much as we would all like, but I want the court to understand Sandy is a public defender contractor in the 9th and in the 5th. In the 5th, it is a homicide contract. Now, we've taken steps, so she's not taking those cases anymore, but she has outstanding ones. The problem we have in the 9th and the 5th, and I apologize, I haven't done the research for around the state, but I can tell you in the 9th and the 5th, we don't have enough DAs, and we don't have enough public defenders. From my side, as a private attorney, You cannot get communication with the district attorney's office to try to get cases resolved. They go all the way to docket call. You can send out pleas of your own. And Sandy, with all due respect to the defendants, Sandy gets assigned, for lack of a better word, the worst of the defendants, the ones that the public defender's office is very aware of, the ones they know they're going to have difficulties on, and they farm them out. And so Sandy, under her contract, she has an obligation to take these clients. I believe in speaking with a couple of the other contract attorneys, there are procedures if you're feeling overwhelmed to try to set up times with Randy Chavis, to try to set up times to try to figure out a way to lessen the load. But the problem is if we lessen the load, there's no one else to take them. Sandy currently has over 200 active public defender contract cases, primarily in the 9th and some in the 5th. She gets good results. It's
Ask you about that because it doesn't, some of the, and I realize these are just out, the 11 complaints have not been adjudicated. The allegations aren't just about a lack of communication. Sometimes it's not relaying a plea offer. We're not showing up to court. We're not consulting a client who's in custody that she needs a continuance because she still hasn't done the investigation. It's things that are in addition to the communication. I do have some concerns as well. I just don't think it's only the communication. And then my second question is, under the consent decree, and I don't have it in front of me, unfortunately, but under the consent decree, do you think revocation of the formal reprimand is the only consequence? And what does that look like?
Well, so to answer the first question,
Oh, sorry. Yeah, you still haven't answered my question.
I'm sorry.
So,
Going back,
but yes to all.
I'm going to go back to the mental health. Sandy has stated in her response, and we've personally watched it in the 9th. Do I believe Sandy is suffering from depression? Absolutely. Has Sandy stated in her response that she's suffering from depression? Absolutely. She has met with a doctor. She is on medication. She has follow-up appointments that is going to increase her medication. She's also on a waiting list for individual therapy. I have personally made calls, and I'll be the first to state, it's only in the last few days, but I've made calls to multiple mental health therapists. They all have a waiting list. And so I have calls into mental health resources, Be Well Counseling, Clovis Counseling, Life Changes Counseling, to try to get her on track as quickly as possible. But I see it in my divorce and my custody cases. There is a waiting list. The mental health treatment that's available right now in New Mexico is tough, and the waiting list is long. And we're trying to get Sandy the help that she needs. We're trying to get her to stay on track.
To the state bar.
I have not personally.
Okay. I mean, they have a whole system
Yes.
for this.
And some virtual options now that are.
Right. And I
don't even-
actually,
yeah.
I contacted a place called Agape, AGAPE, and they have online counseling. I'm waiting on a call back from them. But going to the other complaints, yes, there are complaints about plea offers, and I'm not going to state that it's this way in every case. I speak from experience. We show up at these last docket calls, no return calls, no communication, and you get to the docket call and you have one of the 3 live district attorneys in the office covering the case, and the actual DA on the case is not there, and the question is asked, has a plea been offered? Well, I'm sure it has, Your Honor. Let me check notes. And you'll have a stand-in district attorney make a comment in front of the defendant that things have happened that haven't. And I'm not saying that's always the case, but it is. It's a mess, and it's grueling, it's a grind, and it's overwhelming. I'm not here to make excuses for Sandy, and you're going to find that Sandy's not here to make excuses. She is focused on her clients. She needs to be more focused on the discipline board as well. There's a rule on it, without a doubt. Without a doubt, there's been a violation of that rule. No one's here to say otherwise.
Sounds also that she needs to address these issues,
Absolutely.
depression. So is there a plan in place to do that? Or
There,
let me ask you this.
yes, sir.
I can read her response, and I can read her prayer. What is it that you all are asking this court to do today?
Well, I can tell,
Given everything that's happened in the past year and a half, her current situation, her current needs, the needs of her clients, and the needs of the administration of justice, what is it that you all are proposing?
I stand by my comments that she has actually on fairly fast track through these, she has a lot of pretrial detention clients. She has ultimately met the needs of her clients. She has gotten dismissals, very good deals. The courts praise her for the work she does. But as to the needs, as I stated, she has met with her medical provider. She has gotten onto medication. She is actively under the deferred agreement that we had. She is no longer taking these cases in the fifth, trying to reduce any type of travel that she would have to do so that she can focus just on the 9th. She has made arrangements with other counsel to step in and co-counsel cases with her per the agreement. She is trying to get that help. So what we're asking the court to do today, we know there's going to be further discipline. We recognize that. We're asking the court to put her on a stricter level of probation, put her on a higher level of supervision. You saw in the response, and I did reach out to Ben Herman, who is her supervisor, and he said, I apologize. I thought I was supposed to meet with her and send in a report if there were concerns. It's my understanding that Mr. Herman had taken care of that and sent in the reports. And I have personally spoken to him. He's a friend and a colleague, and he does meet with her. Yes, Justice
So-
Bacon.
This is where, again, life happens and it gets complicated and all of those things, but you've admitted here today, you've stipulated essentially that she has continued to fail to cooperate. That's a new charge. She said she was going to be submitting the reports. That hasn't happened. It's a new charge. I mean, it's bigger. It's at every step. It's become bigger and bigger and bigger. And so while I get there needs to be due process for these 11 new complaints, some of it is evident in front of us today in failure to cooperate. And that's why she got in trouble in the first place.
I understand.
And so I don't know how we make it a higher level without somebody literally having to go to sit in every single case, go through every single file 24 hours a day and supervise. And I'm not sure that's doable or that it's fair to the person who would be tasked with it.
No, and I understand that.
So I don't know what higher means.
Well, I think the biggest issue that we have with Ms. Gallagher and the complaints being made against her, I can't stress enough, it's not that she's, apologize for the double negative, not taking care of her clients. She actually is getting the job done when it comes to the clients. She has these outstanding complaints, she's tending to them, and she's focusing on getting the job done for the clients and not focusing on responding to the discipline board. And I understand that's a problem. I 100% do. But her in court, I don't believe Ms. Gallagher needs someone to sit as co-counsel. I don't believe she needs someone to supervise whether she's interpreting the statute right or whether she's coming up with a fair resolution or protecting them in trial. She is an excellent, excellent attorney.
But I can't get over the fact, she hasn't responded to a single complaint out of the 11 on time, not one.
I understand.
To me, that's basic lawyering, is meeting the deadline, filing your responses on time, or asking for an extension. None of that happened here. So to me, it's going above and beyond communicating with the client. So I'm just wondering how you respond to that.
No, I understand, and by no means would I ever disrespect Counsel Gonzalez or the discipline board. I understand they're a part of the process, but what you're not seeing is Sandy failing to miss deadlines in her cases themselves, Sandy failing her clients in the cases themselves, not appearing for jury trials, not appearing for cases. I'm not downplaying in the least the role of the discipline board, but she needs to understand that there's a focus to the discipline board as well as to the clients. I understand that. But I stand by the fact of what I've watched, that she is capable and is a very good attorney. And with that being said, and if I'm allowed, I do want the court to hear from Ms. Gallagher. And I see that I'm down to 4 minutes and 44 seconds. If I could turn it over, I would greatly appreciate it. Ms. Gallagher, if you could step up, I believe Chief Justice will swear you in.
Ms. Gallagher,
Yes, sir.
you solemnly swear or affirm or appellate law that testimony you're about to give will be the truth, all truth, and nothing but the truth.
I do.
So Ms. Gallagher, we do have some rules here. We'll give you a little over 4 minutes. But
Okay,
that's where we're going to stop, okay?
thank you.
All right, go ahead.
First, I want to tell the court that every disciplinary complaint that I have had has been responded to. There were several, a couple of months ago that I responded to, and they apparently weren't received, so I resent them. Several of these came to me last week, and what had happened is I had gone through a change of address, and some of them, I guess, were returned to the disciplinary board. Someone emailed me and said that when I changed my address, I had both my PO box and my street address on my bar information, so I'll take care of that. But they came to me last week and they've all been responded to, every single one of them. One of them, the deadline wasn't even passed and I have already responded to it. Two of them were from family members of one of my clients. They didn't put my client's name or case number in there, so I have no idea who they're talking about. I tried to figure it out, but I responded to that and asked for permission to contact them and find out who they were talking about. I wasn't sure if that was appropriate. I will tell the court that I have not taken private cases now for over 1.5 years. All I do is a public defender contract. I used to have a varied practice, but once I started doing homicide cases, there was no time for that. And so I refer them out. I told Randy Chavez a year ago in October I was not taking any more homicide cases. We did have a new contract period that started last November. I didn't bid on one because of what was going on with my family and their situation, the things that were happening. Also told Mr. Chavez I would no longer take any cases outside the 9th Judicial District. I do not. I can tell you that I'm asked almost daily to take homicide cases all over the state, and that I'm asked to take cases in other judicial districts. And I always tell them no. I talked to Mr. Chavez again about it this year. They did a new RFP and they tried to get more contract attorneys because there are only 2 offices in the 9th that do the cases. Nobody even applied for the contracts. So it was not for me a good decision. Of course, I don't, can't tell the future, but to take on a homicide contract, although I have won a really huge one right after I started doing it. It was a triple murder case with 4 other counts of aggravated battery. And they found him not guilty in less than 1.5 hours. So when I'm in court and I'm prepared for trials, and Judge Tatum told me that the other day, now your clients, some of them have complained about not speaking to you often enough, but when you go in the courtroom, you're a phenomenal attorney. Many of the cases where people have complained, such as Bronson Arrington, we tried his case already. He was found not guilty on all but 1 count, which I really do believe will be overturned on appeal. Avery Miller, who's working very well with me to get ready for his trial. He's told Judge Tatum he's comfortable with me. Lorenzo Medina, that was an issue where I could not get the district attorney to respond for months and months on a plea. Well, finally, when I got him to respond after I cornered him, I got a really good deal for Mr. Medina because he was charged with trafficking, but he was allowed to plead to possession and only do his 4-year habitual time, which is down there a great deal. I am to the point now of talking to Mr. Chavez and asking him to please reassign some of my homicide cases that I don't have co-counsel on. I have one, for instance, in the end of April that is, I'm doing it with Gary Mitchell. We're doing co-defendants. I realized, and it wasn't until September, that I was suffering from depression. And I went to the doctor immediately and I got put on medication. It worked immediately. I'm sleeping, I have my energy back. I'm doing much better. I'm just trying to get everything caught up at this point. There will be no more missed deadlines with the disciplinary board. I can tell the court. And I really do feel like I'm much more like myself than I have been for a while. It just took me a long time to realize that's what it was. And when I realized it, I immediately got help. I don't want to live like that, and I don't want to put anyone through that with me either. So I can tell the court that I have absolutely 100% done what I need to address the issue. I've never been diagnosed with a mental health condition that requires me to take medicine, but I have had several really big tragedies in my family over my lifetime. But when that happens, I deal with it right away. Nobody has to have an intervention or tell me you need to go get help. I go do it. And so I want you to know I'm doing everything that I can to make sure that this does not happen again.
Thank you, Ms. Clark.
Thank you.
Gonzalez.
I'll be brief. Mr. Harmon stated that Ms. Gallagher currently has 200 active cases. That is concerning considering her level of communication, the issue she's having with communication. As Justice Zamora stated, if Ms. Gallagher is not responding to our office, to our deadlines, I really find it hard to believe that she's on top of all her cases, considering the type of complaints that we've been receiving. As Mr. Harmon stated, I don't know what level of supervision on probation more we could offer. Especially since I have not seen the fruits of that supervised probation. I've not received any reports.
So what do you want us to do today? What are you asking?
I'm asking that Ms. Gallagher be suspended. She needs to attend to her personal issues, and she needs to take the time to get her law office management in place. I do not believe that she is currently fit to practice law.
And the basis for that is?
Just the complaints that we've been receiving, her lack of cooperation with our office.
So what do we do about these unadjudicated complaints? Do we take that into account? And if so, in what way?
Ms. Gallagher stated that she responded to all those complaints. I don't believe she's responded to all of them. I know she did respond to some over the weekend, but I have not had a chance to review those. So once again, without investigating those complaints, without being able, I don't know the veracity of the actual allegations. But what we do know is that Ms. Gallagher has failed to cooperate with the disciplinary process, as she admitted to today.
So do you anticipate, I think I asked this question before, I'm not sure I understood your answer. Do you anticipate after this adjudicating those complaints and either possibly coming back and asking for more discipline? Or what's going to happen after this? Or are you telling us normally indefinite suspension is at least a year, that after a year she can come back and ask to be readmitted? What's going to happen after this?
Depending on if her responses to the complaints, if we will investigate those and dismiss them if necessary, or go to the next step if necessary. Again, if there is going to be new charges that will be filed, it would again probably be failure to cooperate. But again, that was part of the basis of our motion for order to show cause, which is why we're here today.
So you're asking us to act on the basis of the unadjudicated pending complaints?
No, I'm asking that.
But you've argued that over and over, that we have all these complaints. And you are using that as a basis to argue.
No, I'm using the basis of the complaints to show that the the allegations of the complaints are all the same. And again, to show that it's a pattern of misconduct of
Exactly.
not cooperating with our office.
Exactly. So you're asking us to take that into account today, based on your assertion that they're alleging the same pattern of non-cooperation and not paying attention to her clients.
I believe we're here today for her, based on the conduct of her not cooperating with our office. That was the basis of the motion for order to show cause.
Okay. So why argue about all these other complaints?
And it's to show that we don't believe that she's currently fit to practice. She's not taking care of, she's not responding to us. She's not meeting her deadlines with us. And based on the allegations we're receiving, she's not receiving.
Has she in fact responded
To the four in the motion for order to show cause.
to your pending matters here today?
Which pending matters? All 11?
No. The failure to cooperate, has she remedied those failure to cooperate allegations?
For the initial 4, yes.
That's my question. And that's the only thing that's really before us here today, correct?
It's part of the motion for order cause, yes, Your Honor.
All right, thank you. In the matter of S-1-SC-41094, court will take this under advisement. We will recess and deliberate. I'll ask the parties and counsel stay in the courtroom. If we're not able to reach a decision, we will let the clerk of court know and she will release you until that time. Please stay in the courtroom. Court is in recess. be seated. Thank you. Back on the record, S-1-SC-41094, matter of Gallagher. Ms. Gallagher, counsel are present, counsel for disciplinary board are present. Court, having reviewed the pleadings, heard oral argument, been otherwise advised, will grant the verified motion for order to show cause. The actual formal reprimand agreement was not made part of the record, so the court will rely on the representation in the verified motion. The deferral will be removed. Formal reprimand will be entered. And as required under the rule, the disciplinary board will provide that language to the court for entry of the formal reprimand. Supervised probation is lifted. The respondent is suspended for practice of law for a time period not less than 6 months. This is in accordance with 17206G, 17207B. The respondent may seek reinstatement after that time under the following condition: that she agree to a mental health evaluation overseen by JLAP and provide JLAP the necessary cooperation and waivers to allow the disciplinary board access to any reasonable recommendation with regard to treatment and shall cooperate in that treatment. At that time, she may seek reinstatement, and the disciplinary board will be required at the same time under 27, strike that 207A4C. To represent to the court that there's no longer a substantial probability of harm, loss, or damage to the public. And once the D board certifies that that does not exist, the court will consider an application for reinstatement after those 6 months. Ms. Gallagher, the court has, I want you to understand this, has real understanding and empathy for what you are going through and have gone through, and appreciates your efforts to address that. At the same time, we have equal concerns with regard to the individuals you represent, and we are not blind to the situation that you confront, that public defender confronts in that part of the state especially. I respectfully suggest, and I'll end with this final condition, that either you or your counsel have a disciplinary board on speed dial. Communication is important, and it's very important to the disciplinary board. The final condition here is if there are additional complaints for lack of cooperation that are not addressed, meaning there is no cooperation with the disciplinary board, that may lead to indefinite suspension or revocation of your license. Do you understand that? Okay. I will start with the disciplinary board. Do you have any questions with regard to the court's order today? Council, any questions? One moment, please. Okay, disciplinary board, we will include costs for the proceeding in addition to the order in accordance with the rule. Okay? All right. All right, in the matter of S-1-SC-41094, this matter is being submitted. We will await the language of formal reprimand. And Ms. Gallagher, we wish you the best. Court is in recess.